Section 1 clause 1 that talk about title, section 2 that about extent, and this statute has the extraterritorial jurisdiction. Then the section 1 clause 3 is about the applicability. Only these things we have discussed. And I said that in today class we will discuss definitions. But before that, there is two more subsection in section 1 that I would like to discuss here, and that is important. See, the territorial extent or the territorial applicability of the section of this statute we have discussed, that this statute will apply to all the person who are residing and the doing an activity or the contravention that is related to the computer source or computer network situated in India, and even to the outside persons to do the activity. Section 1 clause 2 read with section 75 against the computer or computer network, computer system situated in India. So that is the territorial nexus, that the thing that is or the offense or the effect of the offense is on the computer, computer network, computer system situated in India. As to the applicability, see, there is one section, the section 4, and section 4 says, or you can say the section 4 legally recognize the Information Technology Act or the activity done by the IT. Now we are bound to do certain things that has to be in the written form. Okay, whenever you apply for a job, you have to do in the written form. Whenever you make the contract, that also many times you make in the written form. As per the Indian Contract Act, the contract, there is no requirement that contract always be in the written form. Okay, then like many other documents or activity we done in the written or typewritten or etc. form, and the authenticity of that is determined by the signature. Suppose a letter is issued by a competent authority, suppose the Vice Chancellor of Delhi University or the Dean of Law Faculty, then we see that whether this is signed by the Dean and it is a proper sign or signed by that person or not. So that is the way of checking the authenticity. In the cyberspace, when we send one letter or when we send one communication, so how to secure the authenticity of that document, that this is issued by this particular authority. And for that there is the method of encryption. The message has to be encrypted and then decrypted by the receiver, and this is known as the electronic signature. Okay, electronic signature and digital signature, there are the two ways. More we will discuss in our later classes. And so I think you all have witnessed that when you download your certificate, like your OBC certificate, SC certificate issued by the state, or when you income tax or the RTO services, the document you get, and when you take it print out of that, you will find that it is written a line that it is digitally signed. And so that is the way of authentication. So section 4 talking about the legal recognition. Now the question is that I said that we are discussing that what is the applicability, the subject matter applicability of this particular act, because the territorial applicability we have discussed under section 1 clause 2. Section 4, if you have bare act, you can read, I'm reading that where any law provides that the information or any other matter shall be in writing or in typewritten or in printed form, then notwithstanding anything contained in any such law, such required shall be deemed to have been satisfied if such information or matter is rendered or made available in electronic form and accessible so as to be usable for subsequent reference. And so issuing the notice on the website giving the advertisement digitally or online, even giving the summon on the WhatsApp, or many other things that we are doing electronically are now perfectly legally valid, because section 4 is recognizing it. Now come to the section 1 clause 4. Section 1 clause 4 said that to the certain transactions, to the certain transaction or to the certain contract, document, not contract, to the certain document and transaction, IT Act will not apply. That means section 4 will not apply, and so those transactions that are excluded by section 1 clause 4 would not get the benefit of section 4. Okay. Now the question is, what are those transactions and what is the logic of excluding those transactions? So those transactions are as per specified in the first schedule. See, this statute originally had 4 schedules attached to it, like our constitution has originally 8 schedules. 4 schedule later on added to the constitution, but here 2 schedule later on repealed. And in the first schedule there are 6 documents, 6 transactions mentioned, and those transactions by virtue of section 1 clause 4 are excluded. What are those transactions? So go to the first schedule. Any of you have Bear Act with you? Yes? Any of you?
Yes, sir.
Yes. So find out this schedule that is attached there. Did you find?
Yes, sir.
Yes. Please read it.
Which one's the first schedule?
First schedule. The documents or the transaction
Documents
to which
or
the
transactions to
not.
which the act shall not apply.
Yeah.
Description of documents.
Now see, it's very important. Just stop 1 minute. See, it's very important. Section 1 clause 4 is telling the subject extension of IT or the subject matter jurisdiction. It's not that to every transaction the IT will apply. Section, as I already explained, that section 4 is recognizing those activities that we can do in the written form, in typewritten form, in printed form, if that is done in the electronic way. Now the question is that whether it is applied to all type of documents or transaction, and section 1 clause 4 is excluding these. Okay. Yes, please read.
The first one, that is the negotiable instrument other than a check as defined in section 13 of Negotiable Instruments Act 1881.
Yeah, stop for a while. See, the Negotiable Instrument Act, I think you either it is in your this time in your as a paper, or maybe in the next semester, in the 6th semester. There is this act, Negotiable Instrument Act, and section 13 of the Negotiable Instrument Act define that what is Negotiable Instrument Act. A promissory note, bill of exchange, or check payable either to order or to the bearer is the negotiable instrument. 3 तरह के होते हैं, promissory note, bill of exchange and check. ये सेक्शन 13 के हिसाब से 3 जो इंस्ट्रूमेंट्स हैं, these are the negotiable instrument, and whole Negotiable Instrument Act is related to how their transaction is done, the liability, and the remedies available to the person dealing in the negotiable instrument. But this first, in the first number in this schedule is excluding the check. That means to the check, IT Act will apply. Okay, and so there is the concept of the even this digital check. Section 81 capital A basically even has this truncated and electronic check. Just if you have direct with you, please find section 81 capital A. Yeah, read the marginal note only.
Yes. Application of the Act to electronic check and
Yes, that
truncated
means
check.
the exclusion from the schedule is correct, that yes, IT Act will apply to the electronic check and truncated check. Then the second category is, yes, please read second one, power of attorney.
A power of attorney as defined in Section 1A of the Powers of Attorney Act,
Yes.
1882.
See, there is a statute known as Power of Attorney Act, and you all have heard the general power of attorney and specific power of attorney, GPA and SPA. In Delhi, it is very common. If someone does not have the title or ownership of the property, so he cannot sell the property, because one cannot give another what he does not have. This is the very cardinal principle. जब किसी चीज पे आप ही का अधिकार नहीं तो आप दूसरे को क्या ट्रांसफर करोगे? And there are many allotted property on the 99 lease or other type of the thing, and to which one person does not have the title, ownership uski hai nahi. And so in that case they have this use of this GPA, general power of attorney. So GPA hota kya hai? This power of attorney hota kya hai? Power of attorney is basically an instrument that empowering a specified person to act for or in the name of person executing. So there are two persons required, and person A if execute in the name of person B, then person B can do the activity in the name, or you can say on behalf of A. This is used mainly for managing the property, vehicles, etc., etc. The third category is, I am reading, a trust is defined under section 3. You trust that we call in Hindi Nyas. There are many trusts registered under the Indian Trust Act 1882. How the trust is created or what is the trust, section 3 define. That trust is an obligation annexed to the ownership of the property. So there has to be a property, then the trustee, the beneficiary, okay, and this this ownership of this property that is assigned to this trust, there is an obligation that the profit that arise out of that property would be for the benefit of the others, that is known as beneficiary, and sometimes even the owner. So that is trust. The fourth is a will. I think you all know the will. Hindi movies में तो will होता है वसीयत. So will an instrument by which property is disposed, disposition. It's a testamentary disposition by whatever name is known as will, and there is a full statute, Indian Succession Act 1925. It is different from Hindu Succession Act 1955. Indian Succession Act 1925 is applicable to the person, and there the will is defined. Under the Hindu Succession Act, there is, I think, section 30. There the will has not been defined. It is just empowering that an Hindu can make the will. But what is actually will? So will is, as per section 2 clause H of the Indian Succession Act, that testamentary disposition by whatever name it called. And then later on, in this clause itself saying including any other testamentary disposition by whatever name it is called. Now, there is increasing trend of having digital will for bequeathing the digital property. Even I think you all have got this notice from the Facebook about the will that who will write your obituary. You have to, give the details of that person who will manage your account, because on the Facebook now the account of dead person are outnumber than account of living person. And so, because time is changing, technology is changing, there are many way or there are many instances of this digital will, and this electronic assets are bequeathed. And so the concept of electronic will has come into the existence. There is also this just give me the way it is created, that it had to be executed. It is first, the will is written in the digital form, then it is authenticating by affixing the digital signature of the executant, which he obtained from duly licensed certifying authority, and thus the this became an electronic will, which is authoritatively elaborate as to how the digital asset of the client will be bequeathed after his death. Even electronic stamping or e-stamping has started happening in respect of registration of the sale deed for the transfer of the immovable property. I think we all see this e-stamping. The next clause is excluding the transfer of immovable property. Any contract of sale of conveyance of immovable property or any interest in such property. Conveyance means transfer of title from one person to the another person. So sale of immovable property or any interest arising out, that means the lease, the mortgage, that cannot be in the electronic form. But as I said, that e-stamping is in the come into the fashion. And with that, the question is that what is the justification that government has excluded all these documents or the transactions for the applicability of the Information Technology Act 2000. The only justification that immovable property and the registration of the immovable property is very important. Otherwise, that can be, because the to the movable property you can make the contract, and it is happening every day. You see that there is the the sale of the movable property on various e-platforms, whether it is Amazon, whether it is Flipkart, etc. But the same is not there, because immovable property cannot be treated with the movable property, and the greater precaution is required. Whenever you purchase or sell the property, there is huge requirement, because immovable property is very important one for the purpose of, because it is the source of revenue. So sale of the immovable property is a great source of the revenue, though through the movable property also the government get the GST. But in case of immovable property, second thing is that because immovable property cannot destroy, so people and even the states say it with the greater precaution. With the other things like the will is excluding, but there is the trend of having this thing. And then the question is that if this type of electronic will is conducting, or if any transaction that is excluded if done through Information Technology Act, what would be the consequence? One say that even maybe that particular statute giving the legality, but then there is a question that section 80 of the IT Act have the overriding effect. What is the overriding effect? That this statute or the principle of this statute will prevail over the other statute. Section 80, not 80, section 81, sorry. Yes, please, any of you read, please, section 81.
Okay, sir, I will. Act to have overriding effect. The provisions of this Act shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force, provided that nothing contained in this Act shall restrict any person from exercising any right conferred under the Copyright Act 1957
Yes. So
or the
see, this
Patent Act
provision is very
1970.
clear. Yes, the provision is very clear that this act have the overriding effect. It says that the provision of this act shall have effect, notwithstanding whatever said in the other act is not important, and despite that is written, the provision of this statute will prevail. Okay, and then excluding by the proviso that nothing contained in this act shall restrict any person from exercising any right conferred under the Copyright Act or the Patent Act. If under these two provision IPR Act, if there is even some provisions, principles that working, so in that case these act will prevail. That means a proviso is creating to having or nullifying the effect or overriding effect created by the section 81. Now come to the section 81A that talk about the electronic check and a truncated check. And in the explanation, it says that the meaning of the electronic check and truncated check shall be the same meaning as assigned to them in section 6 of negotiable instrument. See, the negotiable instrument was enacted in 1881, and at that time there was even legislature has not expected that there would be the time when electronic check would be in the circulation. So it was through the amendment that the definition of electronic check in electronic form or electronic check or truncated check has been added. And what is the electronic check? That a check which contains the exact mirror image of the paper check and is generated, written or signed in the secure system. So the security attached to it, so that when it move to in the cyberspace, no one can manipulate it, ensuring the minimum safety standard with the use of digital signature with or without biometric signature. So digital signature or that protection is required, but it's not necessary that always biometric signature is a an asymmetric crypto system. That means by any encryptions, it has to be secured when it move in the cyberspace. Then truncated check means a check in which which is truncated during the course of clearing cycle, either by clearing house or by bank, by whatever paying or receiving payment immediately on generation of an electronic image for transmission, substituting the further physical movement of the check. So truncated means fatawa, tutawa, fatawa. So when the electronic image is taken, and after that this physical check is truncated, so that is known as the truncated check. And that means that what is excluded in the schedule on the first point, that it would not apply to the negotiable instrument other than the check. That means the check is excluded there, and so by virtue of section 1 clause 2 with schedule, the effect is that to the check IT Act will apply, and that's why there is this thing. But there is little justification with respect to excluding the will, with respect to excluding the trust, etc. Only the justification that at the time when this act came, there was no proper the legal structure or the framework. But after the 21 year, there is not good justification, and government is keeping its eyes closed, not seeing in this direction. But there is later or sooner the development would be there and all these things would be removed. So this is about the subject matter applicability of the IT Act. Now, close to the section 1, clause 4, there is one proviso also attached there. Yes, Vikash, I will come to your question. First, let me see this proviso that provided that the central government may, by notification in the official gazette, amend the first schedule by way of addition or deletion. That means in the proviso, through the proviso, the power is given to the central government, the you can say the delegation to the central government, that they can delete the item, they can add the item. And in the past they did it, but that was not in the proper way, or with the advancement of the technology or advancement of the transactions. And then the clause 1.5 is about the laying requirement. See, this is the principle, or you can say this is the safeguard, that whenever the power is delegated, or whenever there is the delegated legislation, like the power is delegated to the central government, that they can add or they can delete, like in the Essential Commodity Act. But then whatever the central government will do, how that has to be checked, because the lawmaking power is the parliament. So that is secured through the legislator check, or by requirement of laying. So whatever rules, if they add or they delete, that has to be laid before the each house of the parliament, or us parliament mein jo committees hai, they will decide whether it is done in consonance with the very purpose of that. Yes, Vikas Deshmukh ask.
Sir, what I am asking, that when the check has been
Truncated,
transcripted, yes, yes,
truncated,
the,
truncated.
yeah, yeah, truncated. So then IT Act came into force, right?
The truncated check also, and to the electronic check also. See, when the image, sometimes the transaction done between the two banks without physically moving the check. So see the definition of the electronic check, that is the image, and that image when sent, it is secured, that means it is encrypted. So that type of the thing it is saying. And when the suppose there is that electronic image is taken, and after that check is truncated, वो फट जाता है, तो उसको भी truncated check कहते हैं. It's not talking about that if there is a check, physical check, and it truncated, उसके आफ्टर इमेज की वो बात नहीं कर रहे. सो ये these two category are covered. That means that check, when we talk about electronic check, that means there is the scope that the check can be in the electronic form. So similarly, like the section 4 saying that the activity that we can done in the written form, same thing we can done through the electronic form. That does not mean that now we cannot done in the written form. वो केवल रिकॉग्नाइज कर रहा है, आप रिटर्न में भी कर सकते हो, आप इलेक्ट्रॉनिक से भी कर सकते हो. सिमिलरली विद रिस्पेक्ट टू द चेक आप इलेक्ट्रॉनिक चेक भी हो सकता है, और आपका नॉर्मल चेक भी हो सकता है. यस विकास, एनीथिंग एल्स?
Sir, imagine a situation where the check has been transcribed, and check position is tired of. Means that check is ruptured one. So in that case, what would be the whether applicable IT law will be applicable?
See, no. See, when the IT law applicability means that whether the check can be electronic form or not. Applicability means section 4 की applicability होगी या नहीं होगी, चेक क्या डिजिटल फॉर्म में हो सकते हैं. What you are asking is about that कि कोई चेक फिजिकल फॉर्म में है, रेप्चर हो जाता है. चेक आपका फिजिकल फॉर्म में हो, रेप्चर हो या नहीं हो, आईटी एक्ट का एप्लीकेबिलिटी का क्या मतलब समझते हो? एप्लीकेबिलिटी का मतलब है कि जो चेक का जो कॉन्सेप्ट है, क्या हम चेक रिटर्न फॉर्म फिजिकल फॉर्म में ही हो सकता है, या चेक को हम इलेक्ट्रॉनिक फॉर्म में भी ला सकते हैं, उसका मतलब होता है एप्लीकेबिलिटी का मतलब. आर यू गेटिंग माय आंसर?
Okay, sir. Yeah. Get.
Okay. So
Sir?
like yes, someone asking.
Sir, when we say the will are not included in this IT law, well, what I'm saying is in like these days, what happened whenever people get insurance, they don't put the nominee name, but later on they can manage themselves going online. Okay, whether it's with the account or with the insurance. So insurance and the nominees in that, this is a kind of a will itself, right? If the person died, the amount goes to so and so person. So in this way, it comes into IT law.
No, that will is you can say in the nature of terms and condition. The will here means the will as it is defined under Section 2H of the Indian Succession Act 1925. This act is not referring other type of the will like we make when we opening the account or to the insurance that you are referring. This act is will that is applicable under the Indian Succession Act with respect to the that immovable property and most probably to the immovable property that aspect. यस बैंकिंग में होता है इवन व्हेन वी ओपन द अकाउंट वहां पे भी वो इलेक्ट्रॉनिक फॉर्म में भी होती है आजकल तो आप ऑनलाइन सब कुछ अप्लाई कर सकते हो सो दैट इज देयर ओके दीपक
Okay, sir. So you mean to say that exactly the will defines in the
yeah
section
the
clause
exactly
H?
exactly it's excluding that will that under the Indian Succession Act that define
Okay.
or that have the its implication under the Indian Succession Act that will cannot be in the electronic form.
Okay, sir. Thank you.
Okay. Now, see, some outline should also we can discuss. As see, this statute has earlier it has 4 schedule. Now it has only 2 schedule because 2 schedules has been repealed. In these two schedules, one is the we already have discussed related to the documents or transaction that is excluded from the applicability of the IT Act. Second is about the electronic signature and that the different technologies with respect to the electronic signature. Then the statute has 94 sections, the electronic signature or electronic authentication technique and the procedure, the second schedule. It has 94 sections and all those sections are divided into 13 chapters. Similar chapter under the similar chapter under one similar sections under one chapter. So the first chapter is about preliminary, that section 1 and section 2 definitions. Then under chapter 2 we have this electronic governance, and from section 4 to 10A there are different rules of electronic governance. Like section 4 is recognizing the activity that we can done by through the written document, typewritten document, if it is done through the electronic means also. Similarly, section 5 is using the recognition of electronic signatures. The section 6 is use of electronic record and electronic signature in government and its agency. Section 6A is delivery of service by service providers. So these the things related to the governance are covered under the chapter 3. Chapter 2 is about digital signature and electronic signature, section 3 to section 3A. Okay, I missed chapter 2 earlier. So chapter 2 is about digital signature and electronic signature, 3 and section 3A. Section 3 is about electronic governance from section 4 to 10A. Then chapter 4 is supporting the Indian Contract Act 1872. The principle of attribution, acknowledgement and dispatch of electronic records, 3 sections 11, 12 and 13. Then chapter 5 is secure electronic record and secure electronic signature, only 3 sections 14, 15 and 16. Chapter 6 is regulation of certifying authorities. So this is PKI, public key infrastructure, and this PKI is a topic under our second chapter where we will discuss that how certifying authorities are regulated, who can apply for certifying authority, can a foreign agency also apply for certifying authority, and the procedure of getting the certifying authority and their regulation method. Then chapter 7 is electronic signature certificates. Chapter 8 is duties of the subscriber. Okay, So if anyone get this electronic signature certificate, there are certain duties attached to it, to those duties. And then chapter 9 is about the cyber wrongs, or you can say cyber torts, penalty, compensation, and adjudication. Section 46, I just gave the idea in our previous classes about the adjudicatory office. Okay. Then chapter 10 is the appellate tribunal. Okay. So under section 14 of the Telecom Regulatory Authority Act 1997, that tribunal also has to decide the dispute of the the IT after if one of the parties is not satisfied with the decision of the AO, adjudicating official. Chapter 11 is about offenses, and it is from section 65 to section 78. Earlier, this chapter 10 was from section 48 to the 64. Many of the provisions under chapter 10 already repealed, because those were with respect to the the terms, service condition, etc. But that is already, because we have replaced the appellate tribunal. Earlier it was to constitute a new tribunal, then the government thought that it is not possible, and then they gave the power to the already established tribunal, like in the competition law case. Then the 11th chapter, as I said, is about the cyber offenses from section 65 to 78. Then chapter 12 is about the intermediary. It excludes the liability of intermediary when intermediary shows the due diligence. And so the discussion is about the due diligence, what constitutes the due diligence. The earlier regulation of 2011 and the latest regulation of 2021 related to the intermediary we will discuss here. Chapter 12A is also added by way of amendment, examiner of electronic evidence, only one section, 79 capital A. Then chapter 13 is miscellaneous. Here, who can investigate, the power of police, the overriding effect, the rule making power, the miscellaneous matter covers under it. Okay. So this is the broad outline of the chapter. Then there is salient feature. So to the salient feature, some of the salient feature we can observe now, and rest of the salient feature you will observe when we will have the discussion, more discussion with this particular statute. One salient feature is like it has the extraterritorial applicability. Another silent feature, you can say that it talk about e-governance. The another silent feature that it can talk about, that it having the making the criminal offense of certain activity that have effect on the society, like child pornography, cyber terrorism, pornography, etc. The other is that it recognize uh, the activities, and that in that way it legalize the digital contract, or the digital conversation also. So these are the some of the salient feature. There are other also that with the time we will come into the knowledge, and we will discuss in that. Okay. Now come to the section 2, and that is the definition. See, there are many words that are defined under section 2, but we will not discuss all words now, because some words, if I discuss today, or if I discuss in the preliminary class, you will not get the flavor of that, or you will not be that much excited, or that much interest you will not show. But like the access, what the access meaning. But when we will discuss section 43 small a, section 43 clause small a, there the word access is used. So when we will discuss that section, then I take the what is the meaning of access from this particular definition clause. Here I would like to discuss only those sections, or only those definitions that are very very important to understand this statute, and even that not itself attached to some other things in themselves, they are having some sense, like computer. तो इसमें ऐसा नहीं कि जब यूज होगा तभी पता चलेगा, वैसे भी हम डिस्कस कर सकते हैं. ओके, and I'm not taking the words in the alphabetical order. I'm taking as per my convenience or as per the class convenience. So first I'm taking the word is the computer, because that is the thing from where we will I would like to start. Yes, the word computer, if you see in the common parlance, what you understand by the computer? Yes, any of you can tell me that what you understand by the word computer? Common parlance. I'm not taking the legal meaning. Yes, Shanganak. We call in Hindi na Shanganak. So if someone asks what is computer,
A general machine which facilitate day-to-day working, and it also
or you can say anything that compute. Anything that
yes, yes,
compute is a
that's
computer. Like who is
right,
vendor?
right.
Who vend? What is vendor machine? That vend the vendor machine. So this type of, yes, any instrument. Now see how the law has defined. The legislature has took the full care about defining this particular word, because in many sections, in many offenses, you will find this word computer. And cyber crime is committed in two ways. Either the crime is committed through the computer, or it is committed against the computer. And so computer is a pivotal word. Computer is a basic or important word, and the definition of this word will determine the scope of this provision. I think you remember that in our last class I gave the example of section 299 of the IPC, just to make you understand that if the word death has not been defined, so what would constitute the death under section 299? Would it be the death of the human being, or would it be the death of any living animal? So in that way, it's very important that what is the definition of the computer. See, there are the two rule of the of defining a particular word. One type of the definition is known as exhaustive definition, and other type of the second type of the definition is known as the inclusive definition. So the exhaustive definition means that a word is defined in such a manner that everything is exhausted in it, and there is no possibility to further increase the scope of that word, to further include other things. Okay, and the test, how to determine that a particular definition is exhaustive, it will start with the word means, and some definition is given. So whatever fall under that definition, only that much is there. So the legislature purposefully sometime define a word in exhaustive manner, sometime in the inclusive manner. The second is inclusive definition, and the inclusive definition is that definition that is there is possibility of including other items also of the same nature in that definition. And legislature here does not define but give the list of the subject, list of the similar thing. Okay, and the test to find out that whether a definition is inclusive one, that it start with it includes. Now come to this definition and please read, any of you. Shivani, can you read it? Yes, please, any of you read. Don't waste time. We have only 10 minutes. Who read earlier? किसने पढ़ा था अभी?
Yes, sir, I read.
Okay, Mukesh. They, I think you are
Definitions part.
27. Yeah, you are 27. At least 3, 4 have the Bare Act with you, because only if I speak, and only if I speak, and you are not following what is written on the statute book, so it would not have that much impact on your mind. Yes, please read.
Definitions part.
Hmm. 2, 1I, the definition of word computer.
Okay, sir. Computer means any electronic, magnetic, optical, or other high-speed data processing device or system which performs logical, arithmetic, and memory functions by manipulations of electronic, magnetic, or optical impulses, and includes all input, output, processing, storage, computer software, or communication facilities which are connected or related to the computer in a computer system or computer network.
Yes. So see, have you observed that there is word means when it started computer means, and then includes also. So this definition is basically in two parts. The first part is the exhaustive definition, and the second part is the inclusive definition. This definition is very futuristic and well defined in the widest amplitude, the word computer, just to increase the scope of the provision, the scope of this particular act. I'm taking the first part. The first part of the definition says that computer is a instrument, but it has three conditions. What are those three conditions? The first is about the nature of device. The second is about what function this device do. And third is about how that device does that function. So the nature of the device, that device may be electronic, magnetic, optical, or maybe their combination, that means other high speed data processing device. Okay, or other, and then high speed data processing device. So this high speed data processing device will come or will go with all these words. That means a device that is either electronic or magnetic or optical or other type, maybe their combination, etc., that have very high speed data processing. The fraction of speed it process the data. The second, that what function it does, three function. It must be able to do either of these three function, which logical function. What is logical function? Like A is greater than B, C is less than D, E is equal to F. This type of the function, that is logical function. More also you can understand. Arithmetic function like 3 plus 2, 5 into 4, 12 by 2, this type of the function, arithmetic function. Memory function, storage, retrieval, etc. And the third thing is that how that device do the function, that the device do the function by manipulation of the signals, electronic, optical, and magnetic signals. So the computer, as per the first portion or the first part of the definition given under section 2(1)(I), means any device that is electronic, athwa optical, or magnetic, or other, having high speed data processing nature and able to do logical, arithmetic, and memory function, and these function done by the manipulation of the electronic, magnetic, and optical impulses, signals, is a computer. So this is the exhaustive definition, any device that fall under this category would be computer. Whether in the common sense you call it iPhone, you call it Android phone, you call it mobile, you call it tab, you call it desktop, you call it laptop, or by anything, it is computer. ठीक है? Are you getting my point?
Yes, sir.
Yes, sir. Yes.
Okay.
Yes, sir.
Maybe it is ATM you call, or it you call CCTV, जो भी कहो, उसकी नेचर ये होना चाहिए. ठीक है? Then the second part, and this is inclusive definition. यहाँ पे देखो किसी चीज को डिफाइन नहीं किया है, यहाँ पे कुछ कुछ वर्ड दे दिए, and includes all input. अब यहाँ इनपुट डिवाइस क्या होती है उसे डिफाइन नहीं किया. जो भी इनपुट में आप इंक्लूड कर सको. सोच करो आज हम माउस कीबोर्ड जानते हो, कल को कोई नया और चीज आ जाए जिससे हम इनपुट दे सकते हो, दैट इज आल्सो इंक्लूडेड. आर यू गेटिंग माय पॉइंट? सो व्हाट कैन बी द इनपुट डिवाइसेस? यस, कंप्यूटर तो आप लोग सब कंप्यूटर के बाद के बच्चे हो. प्लीज टेल मी.
Any device who is giving command.
कमांड क्या क्या होती हैं, वो कौन कौन सी हैं? कुछ like our mouse,
keyboard, mouse.
mouse, keyboard. Yes, very well. Thank you, Nishu. Thank you for participating. नहीं तो पता ही नहीं चलता है कि मैं किसको बोल रहा हूँ. विकास and 2-3 guys really helping me. Otherwise, it would be much boring for a teacher to speak on the screen. Okay, then output. What are the output devices? Because don't define that anything that. So I just want to know the name of output device. So it is screen, it is speaker, it is printer, monitor, etc. These are the output device. Then processing. What are the processing device?
RAM, sir. CPU, RAM.
CPU, ROM, etc. Then storage. तो वो स्टोरेज को क्या बोलते हैं वो लोग? स्टोरेज लगती है ना सब में, और स्टोरेज बढ़ाई नहीं जाती.
हार्ड डिस्क सर. हार्ड डिस्क.
GB, sir. What?
Then the computer software. So all computer software, जो भी हमारा कंप्यूटर पे जो सॉफ्टवेयर रन करते हैं, like it may be your window, it may be the specific program that you are running. And then the communication facilities. So like you are you having that, पहले होता था ना जिससे इंटरनेट कनेक्ट करते थे, हम ऐड करते थे, और it is connected through the internet, etc. But these devices itself would not be computer. There is condition that the input, output, processing, storage, computer software or communication facilities must be connected or related to the computer in a computer system or computer network. So maybe in your instrument it is already inbuilt, it is already attached, or maybe from outside you are attaching. Like in the desktop we have keyboard, you are in the mobile you have the keyboard, in the other thing there is the virtual keyboard. Okay, there is the mouse also. Yes.
Excuse me, sir. Really sorry to interrupt you, sir. We have in the class and links is already shared.
Sorry. Just small time. I think 1 minute. So that means, and now there are some mouses that the outer by the cable you connect with your laptop, or sometime it is Bluetooth connected. Even it is not connected by the cord or the cable, but it is connected by the other technology, by the Bluetooth or other mechanism wave, or the keyboard also. So similarly, so if these devices are connected, the word used is connected. It's not saying that whether it should be inbuilt or outbuilt, but if it is connected to the computer, then it would also constitute computer. So with this, I'm I stop here. So rest of it, still we will continue on the computer. There are cases also, 2 cases also we will discuss on that, and then we will move to the next definition. Yes, someone have raised the.
Sir, here I see a headline in the BEAR Act, National Policy on Software Products. Is it enforceable, sir, or just a guiding principle for the government?
Where it is written national policy for? in
In
this
the BEAR Act,
definition?
National Policy on Software Products.
Okay, somewhere in the BEAR Act.
Yes, sir.
Yes, there is policy. There is policy that you say. Yes, that policy is there, and that is.
Is it enforceable, sir?
Yes, yes, it is enforceable. Like we have policy with respect to the forest. We have many policy we have. Okay, so that is there. So with this, I'm winding because
Basically, it is a guiding principle.
yes, yes,
Basically, it
guide.
is a guiding principle to govern. It's a broad framework under which the IT laws has to be enforceable.
Okay, okay, because I have pressed someone of you inform me that you have another class. So rest discussion we will done in the next class. Bye bye. See you.
Okay, thank you, sir.
Thank you, sir.